Good morning, everybody. We'll get started. I'm Lucas Gutentag. I'm the director of the Immigrants' Rights Program for the American Civil Liberties Union. Welcome to this session. We have a very distinguished panel today. Let me introduce them to you very briefly. The more detailed biographies are in your program, so I don't want to spend time on that. But very briefly, to my left, Ana Avendaño, who's the Associate General Counsel and Director of the Immigrant Worker Program with the AFL-CIO, and has worked in this field for a long, long time, and is one of the leading advocates on immigration reform for the labor movement in Washington, D.C. and nationally. Next to Ana is Judge Robert Katzmann of the United States Court of Appeals for the Second Circuit. Judge Katzmann was appointed in 1999, and prior to that had a very distinguished academic career, and in addition to his judicial training is also a trained political scientist. Next to Judge Katzmann is David Martin, who is currently serving as Principal Deputy General Counsel at the Department of Homeland Security for Secretary Napolitano. He is on the faculty of the University of Virginia, where he too has had a very distinguished academic career as a scholar in the field of immigration law, and previously served under Commissioner Doris Meissner as counsel and in other positions at the Immigration Naturalization Service during the Clinton administration. And next to David is Stuart Baker, who is currently a partner at Steptoe & Johnson here in Washington, D.C., and served as Assistant Secretary for Policy in the Department of Homeland Security during the Bush administration just recently, and has extensive experience with serving at DHS just a few years ago. He was there from, I believe it was until 2007, for about 3 years.
No, I just left.
Oh, just left. All right. So for just very recently. So we'll get a very good view from all various perspectives. Let me just say very briefly, what we are going to do is hear from each of the panelists from various perspectives, and then really welcome an exchange both among the panelists and then from all of you. The issues that we are confronting in the immigration arena are obviously deep, long-standing, and complex. This is an issue that raises policy issues, legislative issues, judicial issues, and I think it is generally recognized that regardless of your perspective, the immigration system is in crisis. How we might define that crisis probably varies depending on where we sit and what our point of view is, but I don't think anyone thinks that the current system is good, sustainable, or just. Among the issues are, of course, a huge backlog in immigrants seeking legal status who are eligible but are not being processed because of the way the immigration visa system operates, delaying family unification and other grounds for gaining legal status. A significant undocumented population in the United States that needs to be addressed. The business needs of our national economy are not being met, and questions of proper, just, and effective enforcement of the immigration laws are hotly debated. All of those questions are ones that I think we want to try to grapple with here today. It is also, I think, interesting that increasingly the Supreme Court is addressing immigration issues. If you look at what the number of immigration cases that have reached the Supreme Court in recent years, it has been significant because it's a matter of federal law, because there are splits among the circuits, and so on. It's also notable in that context. I would submit that for the most part, not always, but for the most part, the government's position in recent cases has been rejected, that the Supreme Court has felt that the position advanced by the federal government in the immigration realm, at least in the cases decided this term with an exception, with one exception, has been rejected. So the legal evolution continues, and the court is playing the Supreme Court is playing a significant, an increasingly significant role. Very briefly, I think that where we are today is in some sense a confluence of a number of factors that include, in my view, first and significantly, the last time Congress weighed into this area significantly, the 1996 immigration laws, which dramatically altered the immigration law system, significantly reduced the discretion that exists in the system, significantly increased the detention mandates and authorities that exist under the law, and dramatically affected the jurisdiction of the federal courts to address immigration issues. All of those consequences continue to resonate throughout the immigration system and have contributed to the crisis that we face today. Secondly, the aftermath of 9/11, which in many respects is much less in terms of legislation and much more in terms of the resources that have poured into the immigration system, principally for enforcement, significantly in the border, and conceptually in terms of framing most immigration issues, or all immigration issues, at least in the public debate, in terms of national security. And then third is the last recent effort of comprehensive immigration reform. The failure of 2006 and 2007, where Congress actively debated the issue, generated significant public response, ultimately failed to enact legislation, and where we now see increasingly local governments and to some extent states weighing in and wading in, diving in to immigration regulation. So the failure of so-called comprehensive immigration reform, CIR, has generated many responses, including increasing regulation at the state and local level. So where do we go from here? That's what we're going to hear. And we will talk, as I said, legislative in terms of potential policy changes that the Obama administration is undertaking or considering, legislative proposals, what the effects have been on the bench, and so on. So with that very brief overview, let me start by asking David Martin to give us a sense of DHS today, what policy positions the administration has undertaken, what we might expect, and what your perspective is now coming back into this administration at this time in comparison to what we saw, what you experienced some years ago.
Okay, thank you very much. It's a pleasure to be here today. It's a pleasure to be back in Washington after about 11 years away since I had my INS stint as general counsel. I'm very pleased to be a part of the Obama administration. I had the privilege of starting up on January 21st as acting general counsel then. It's been a great pleasure for me also to work with Secretary Napolitano, who I think is remarkably well equipped for this almost impossible job heading up this very large and sprawling department. I've known her for many years. She actually was a student in the very first class that I taught. We worked together some in the during my time at INS when she was a U.S. attorney. There were some projects we worked closely together on. DHS is a very large department with quite a challenging and diverse mission. It's in its sixth year, or beginning seventh year of operation. As everybody knows, there are a great many challenges, but I think it's important for me to say that there have also been a great many successes that the organization has accomplished. Those usually go unremarked, because if something works well, it just doesn't generate headlines. Things in some of the screening systems, such as U.S. Visit, some other things that have been done on backlog reduction and so forth. I'll mention a few of those. The Secretary has ambitious plans for improving the department across the board, including in the immigration area, but it's important to remember there are high hopes for a lot of things in the administration. Changes are complicated. They have to get worked through an interagency process. That seems to me to be more complicated and highly charged than when I was here 11 years ago, maybe because the politics are that much more divisive now on the immigration issue. So we have to choose our targets. We have to commit to the long haul if we're going to seek changes. And again, one does have to be selective, because it takes a lot of energy to make particular changes. You can't do everything that you might have in mind at once. The President, of course, remains committed to comprehensive immigration reform. He made remarks yesterday at the National Hispanic Prayer Breakfast reiterating his support. It would include a legalization program. It would include some significant enforcement measures and some address, although this remains to be really worked out, some address, of course, to the categories that we have for legal immigration and how to work out a better system for that. We're still consulting and deliberating internally on matters of timing, exact strategies, exact shapes. That's really a process that's just in its early stages. There's a meeting, a very important meeting the President will have with congressional leaders on this subject that's scheduled to take place next Wednesday. In the meantime, those of us at Homeland Security under the Secretary's leadership are really concentrating on administrative initiatives to bring improvements in both enforcement and in the services or benefits side of immigration. Secretary is emphasizing, she always calls smart, tough enforcement, and we really see that as the necessary base to create the political space for comprehensive immigration reform. Let me say just a few things here. I'm only going to take a few minutes right now. We can talk about it more in our dialogue afterwards or questions that you may have. Let me speak first about the benefits side. The emphasis here is to press ahead with some system changes that will help us to reduce at least the processing backlogs. There are also backlogs that are created by the quota system that we have, but the processing backlogs. And here we're really building on a number of things that changes that were made in the previous administration that have equipped us to make real headway on the backlogs. So there was a series of strange glitches in 2007 that really increased the load, the application load enormously, drove processing times to very lengthy times. Citizenship and Immigration Services has made real headway on that. We're nearing our target processing times on adjustment and naturalization cases, and several process changes and added resources in the security check process, the name check process, have really helped to streamline some of that. There's still issues in each one of those, but the picture is much better, and we are getting close. Many locations, processing locations, are at their target processing times of 4 or 5 months for the major benefit applications. One ongoing challenge is how to deal with, at least for some categories, with the problems that are created by the very broad definition of terrorism that we have and the issues of material support to terrorism. Very low threshold for finding that someone has engaged in material support to terrorism. Congress over the years has expanded the definitions there. And so we're catching some people who were our allies in the Vietnam struggle as they apply. They're already here as refugees. They're applying for adjustment of status. They provided assistance to armed groups. How do we deal with that? Well, several steps have been in place using an exemption authority, a discretionary exemption authority. But it took a long time to get that untracked, and the categories that we have been quite useful. Exemptions have been provided to some 7,000 people, but we have a backlog of many thousands right now that aren't covered by those exemptions. We're working hard to try to figure out a way to deal with those. Now, some of those people should be disqualified. Clearly, if somebody has actually provided knowing, willing material support to terrorist activities, we don't want them as part of our to get an immigration benefit. But a number of people are in situations where it really should not present an issue. It's a technical application of that. So we're struggling with that issue. On the enforcement side, a real centerpiece is the E-Verify system, the electronic verification system, a web-based system whereby employers at the time of hire can check documents, can put in key information off the documents that they receive and make sure that that the person is validly authorized to be employed. We're making a number of refinements. We're working on those for greater accuracy. There's added funding. The President proposed a 12% increase in the funding for E-Verify for next year. We've got about 1,000 employers a week who are signing up for this system, generally expressing satisfaction with it. E-Verify, there's still some issues, but it's going to be the centerpiece of long-term enforcement plans. And we're working on building up the capacity and the accuracy of the system, protections for privacy and protections against discrimination. One thing we're really focusing on, or we're beginning to really address in a serious way, is concerns about identity fraud. It's very important for this system not only to be able to verify that the document has a name and a number that match up, but also that this particular person who's presenting it is work authorized. We're putting together a team to really do some very creative and far-reaching thinking about how to improve the capacity of the system to accomplish that objective. New monitoring and compliance staff to make sure employers are using it correctly, and some other steps along those lines. And worksite enforcement, we're making a change in the emphasis or the focus. The point is not to round up large numbers of illegal workers, but really to create a system that maximizes employer compliance. So we've refocused that to emphasize prosecution or serious sanctions for employers with extensive violations, and we've got new arrangements with the Department of Justice to work with the U.S. attorneys to facilitate investigations beforehand and be sure we're ready to prosecute employers who commit egregious violations at the end of the process. On detention, an issue that's mentioned in the lead-in materials here, and I'm sure we'll talk about that some more later on. The Secretary, from very early on, was concerned about that and wanted a thorough review of our detention system, look at alternatives to detention, look at the conditions of detention, look at the arrangements for medical care and attention in the facilities. She appointed very early on, within the first couple of weeks, I think it was, a colleague of hers, the former director of the Department of Corrections for Arizona, Dr. Dora Schreiro, who is a recognized expert and has won awards in many positions that she's had along those lines for improvements that she's brought to various kinds of detention systems. And look, she knows a lot about pretrial systems as well as the punitive systems that apply after somebody has been sentenced. She's doing a very thorough study of all of these arrangements to try to find ways to improve the management, to find ways to use the detention system in a way that will minimize any interference with counsel rights or representation, and to find ways to promote the use of alternatives to detention. Let me just, there's much more I could say, but let me just, for now, close with just a few further comments on detention. If you look at the literature, there's just abundant criticism of various parts of the overall detention system. Lots of questions raised about why do we use detention, why not release more people on their own recognizance or on lower bonds, some pointing to statistics that show certain percentages who show up for their hearings anyway, even when they're released. I think critics of the system need to focus very hard on why it is that the bureaucracy and certainly large swaths of Congress have been so devoted to detention despite these criticisms, many times with very valid points to make about some portions of the detention system. I think the reason for the devotion to that is because, the key reason is because without detention, we have a very poor track record of actually removing people at the end of the process. It's not enough that they simply, from the perspective of a lot of people who look at this, not the immigration specialists, but people who are just looking at it from the outside, it's not enough just to show that people show up for their hearings. If they have a full hearing, they should have a full hearing to present any defenses or claims for relief. But if at the end of that they are not entitled to be here, they get a removal order, it's really important to a lot of people that those removal orders be honored or be enforced. We don't have a good system for that. Various studies, it's hard to get exact numbers on this. Various studies have shown 11% or 15%, that's all, 15% of the people who get final removal orders and aren't detained actually are confirmed as having left the country. So fugitive operation teams, which have also drawn criticism, were meant to try to address that issue. We probably need some other new innovations along those lines. But it's not enough, I just want to emphasize, not enough to criticize elements of the arrangements for detaining people in the process. We really need help from quarters like the people in this room to help design a system that actually succeeds on that critical measure. That after a full and fair hearing, if you get a removal order, you get removed. That's really important. We need to be credible on that and on other parts of our overall enforcement system if we're going to lay a solid base, a solid foundation for comprehensive immigration reform. Thank you.
All right, before addressing some of the questions that David raised, I'd like to hear from Judge Katzmann on the perspective from the bench, and particularly for those of us who were at the earlier session this morning, where the judges from across the various circuits all stressed, I guess with the exception of the D.C. Circuit, stressed the incredible impact of immigration cases on the federal courts of appeals, So now it's an opportunity to hear from the Second Circuit, which was not represented on the panel, and the other issues. Judge Katzman.
Thank you. It's a real honor to be here with such distinguished colleagues. I'd like to give you a sense of my perspective of some of the problems which led me to launch what is now a significant effort in the Second Circuit, thanks to the work of many superb volunteer lawyers to facilitate representation of immigrants. By way of context, in 2002, there was a backlog of some 56,000 cases in the Board of Immigration Appeals, which is the agency from which the Second Circuit and all courts of appeals hear most immigration appeals. And the Attorney General ordered that those cases be dealt with expeditiously, and as a consequence, the 56,000 cases were soon within the purview of the courts of appeals throughout the country. So that if you look at the period between 1999 and 2005, you see that the increase of cases in immigration was substantial. In the Second Circuit, which has 21% of the immigration cases in the country, we went from 4% immigration cases to what is now 40%, 39% immigration cases. The challenges to the circuit courts were that at the time that those cases were moved from the Board of Immigration Appeals, many of the decisions of the Board of Immigration Appeals were simply summary affirmances without any explanation whatsoever. They were single judge affirmances rather than three-member reasoned decisions. And this so-called streamlined procedure was launched so that these cases could move out to the courts of appeals, and as a consequence, the courts of appeals became the first line of effective review in so many of these cases. What we thought was going to be simply a backlog that would be addressed and our problems over time in terms of caseload management would resolve themselves has turned out to be a steady stream of cases. Now, it is true that there have been a number of reforms under the leadership of Juan Osuna. There are far fewer summary affirmances. There are only 5% of those. There are many more three-member BIA decisions, which make our lives easier because we have a good appellate opinion to work with in reviewing the work of the immigration courts. Nevertheless, our caseload remains, in terms of immigration appeals, at some 39%. And in seeing the mass of those cases, I became quite concerned about the quality of representation. You've heard about some of that in in the previous panel. In the Second Circuit, the problem isn't the absence of representation so much as the poor quality of representation, and with disastrous impacts for immigrants. So many times I felt that if only the case had been better argued, as I wrote in an opinion, Aris versus Mukasey, perhaps the results might have been different. And that led me to try to get a handle on the representation issue. And in connection with a lecture that I gave at the bar, the Martin Lecture of the City Bar of New York in 2007. And as I peeled back the process, what I realized was that what we were seeing at the courts of appeals really were only just a very distorted picture, that the problem was much worse than we would have anticipated. if you look at immigration proceedings generally, the data are somewhat mixed, but generally speaking, only 35 to 40% of immigrants have representation in immigration proceedings themselves. And studies after studies have shown that if you have a good lawyer, you're going to do a lot better than if you don't have a lawyer at all. I believe that with respect to detention, with respect to detainees, that I think the figure is even lower. I think it's something like 16 to 25% have lawyers. And so looking at the system from the very outset, most of those cases don't even get to us because they're not lawyers. There's not good lawyering. There's no lawyering. The percentage of cases that are actually appealed to us at the Court of Appeals is quite low. So there's a real systemic problem. If you look at the immigration courts, and of course we review the work of the immigration courts, the immigration judges, there are some 220 immigration judges across the country in some 57 immigration courts. On average, each judge disposes of something like between 1,000 and 1,200 cases a year. The average district judge, the figure for district judge is 483 cases per judge a year. So when you think about it, an immigration judge has to process a number of cases each day. And these cases are very fact-intensive, very difficult to get one's handle on. And there are also problems of resources. Whereas a district judge gets 2 or 3 clerks, a immigration judge has to share 1 clerk with, the figures vary, I think now it's 4 to 5 other judges. There are problems in translation services. If the translation isn't good, we're dealing with immigrants who don't know the language. Translation services are a problem. Recording capacity, technological capacities are a problem. There is a further problem with respect to the movement of immigrants from one facility to another. So if you're picked up and you get a lawyer, if you're able to get a lawyer, but if you are then shipped off to some other facility hundreds of miles away, your relationship with that lawyer may very well end and is likely to end, and then finding another lawyer becomes becomes very, very difficult. The Board of Immigration Appeals, which hears the cases from the immigration courts, was reduced in size from, I believe it was something like 22, 23 judges to 11. And in in 2002, in the years since, Attorney General Gonzalez instituted some reforms to build up the Board of Immigration Appeals to 15. Not all of those positions have been filled, and ideally the number should certainly approach the 22 or 23. If you really wanted to tackle the problem of backlog, you would need far more staff attorneys in the working the Board of Immigration Appeals, and arguably more judges. So what I saw as a problem, in short, from the circuit perspective, was really only the tip of the iceberg. The problem is much greater than what judges from the courts of appeals typically represent. The problem of representation is also exacerbated by the ways in which communities develop of immigrants who are often the victims of very unscrupulous lawyers who are like ambulance chasers. They embed themselves in the community. They're part of the community. Some of them are not even licensed lawyers. And these immigrants fall prey to those kinds of lawyers, notarios, travel agents, et cetera.
Great, thank you very much. I want to come back to the relationship with detention and representation and transfer, some of the policies. But before we do that, Anna, do you want to talk a bit about the perspective from the worker and with regard to enforcement in particular?
Sure. Hi, good morning, everyone. And I'm very happy to be here on this rainy, muggy Saturday morning. I'm going to talk to you a little bit about what Lucas just described as the worker's standpoint or the worker's viewpoint in this whole complex issue of immigration policy. From the worker's standpoint, immigration policy and immigration law must be a component of an agenda for shared prosperity, which means, which requires or focuses on actually improving productivity and quality, limiting wage competition, and strengthening labor standards, especially the right of workers to organize and bargain collectively. To achieve this goal, immigration law must, and immigration policy, must fully protect all workers, which means reducing the exploitation of undocumented workers and reducing the employer's incentive to hire an undocumented workforce. The current immigration system, both in law and practice, actually accomplishes the opposite result. It has actually created a perverse incentive for employers to hire undocumented workers. And let me explain what I mean by that. From our point of view, one of the fundamental flaws in the current law, in the employment, in the IRCA, and the Immigration Reform and Control Act of 1986, is that it essentially deputizes employers to be the agents of the immigration agency of now currently DHS. Employers are required to check documents, to check workers' authorization to work at the beginning of the employment relationship. And the way that the law works and was actually structured, it leaves a lot of room for employers to go through the initial review process with a wink and a nod. And it's only when workers get injured on the job or when they try to organize a union where they complain of sexual harassment that the employer takes out the original form, they call the I-9 form, and says, hey, wait a minute, these documents don't look so good. So Jose or Maria, why don't you come in the office and show me your papers again, or show me a new set of papers. This enforcement structure in and of itself has an incredibly strong chilling effect. Workers know the consequences of complaining, and they know that those consequences aren't just losing their jobs, but also the potential for ending up in a detention center, uprooted from their communities and separated from their families. And also, the current enforcement system has become one of the union-busting tools of choice in industries across the economy, thanks to the Supreme Court's decision in a case called Hoffman Plastic Compounds versus National Labor Relations Board that was issued in March of 2002. In that case, the court decided that an undocumented worker whose rights are violated is not entitled to back pay under the Act. And back pay under the National Labor Relations Act is currently the only economic remedy. So what the Hoffman Plastics case means is that an employer can violate the rights of workers, can deny workers the right to bargain or to organize, and if those workers are undocumented, the employer can do that without any out-of-pocket cost. So I don't think it would come as a surprise to anybody in this room that for the labor movement, the top priorities with regard to immigration enforcement are, one, that whatever mechanism we come up with in immigration reform, the enforcement piece of it, the monitoring piece of it, the compliance piece of it has to be taken out of the hands of employers. And the law must ensure that immigration enforcement doesn't undermine labor standards or interfere with labor law enforcement. And let me tell you why that second point is so important. It's been shown time and time again that the employers who are violating the IRCA's prohibition on the employment of undocumented workers in a systemic way are also operating in violation of very basic workplace laws. I think one of the most vivid recent examples of this is the agri-processors raid, which was a raid of a kosher meat packing plant, the largest in the country at the time in Postville, Iowa, and that raid happened in May of 2008. 600 workers were taken into custody and processed essentially in a cattle field in a way that really brought extreme negative public scrutiny over the department's handling of the processing piece. But what the raid also did, it exposed conditions at the plant that were in some instances much worse than those described in Upton Sinclair's The Jungle. Children, Guatemalan and Salvadoran kids, as young as 13 years old, yielding knives on the cutting room floor, working as long as 17 hours a day, 6 days a week. And lots of women and girls were being harassed by managers, by male supervisors for refusing sexual advances on the job, pervasive wage and hour violations. Now, these were exposed by the raid, but they weren't just simply hysterical cries of advocates, as we've been accused of doing in the past. The state of Iowa, in October of that year, actually charged the company with over 9,000 violations of child labor laws. And one of the many things that was striking about this raid is that the Department of Homeland Security essentially ignored the labor law violations when it was doing its enforcement actions. It did not coordinate enforcement with the Department of Labor, despite ample evidence that DHS was well aware of the labor and wage and hour violations at the plant. Nor, after the raid, did it do anything to ensure that the workers who were the victims of these violations had any mechanism for staying in the United States to testify and really hold the employer accountable for these violations. To the contrary, many of the workers were actually charged criminally for identity fraud in some cases and removed from the country. Now, I could spend at least another hour, if not two, maybe three, going over very similar scenarios. Michael Bianco in Massachusetts, Woodfin Sweets in Emeryville, California, Nebraska Beef in Nebraska, and so on and so on. These are all instances in which the Department of Homeland Security was aware of labor law violations, or should have been aware of labor law violations, and ignored them in favor of strictly enforcing the immigration law. Now, in fact, many of these cases are cataloged in a report that the AFL-CIO that I'm preparing with the National Employment Law Project and American Rights at Work, which will be released soon. That report is called Iced Out: Immigration Enforcement Interference and the Protection of Workers' Rights. What the report makes clear is that these are not aberrations. Entire industries have shifted the way they operate to rely on immigrant labor. Not just immigrant labor, but they're relying on undocumented immigrant labor. And by doing so, they've saved millions and millions of dollars by underpaying workers, by not paying into the state's workers' compensation system, by not paying payroll taxes, et cetera. And time again, we've seen that labor law violations and IRCA violations go hand in hand. Yet, again, under the current immigration enforcement regimes, this scheme, the way that DHS enforces its own law, actually ignores the labor law component of this. Now, the tragic irony of this is that the labor law violations are really what's driving the whole illegal immigration, what's driving illegal immigration into the country, because it's the ability of employers to have a steady pool of workers who are too scared to complain about not being paid or about being sexually harassed or by having to labor in unsafe conditions, or being mislabeled as independent contractors, that's really what's driving the current crisis. And that absolutely has to change. Now, I see that my time is up, but we don't have to wait till actually we get a new law to change the situation. There are administrative remedies, there are administrative fixes right now, and I'm just going to talk about two very quickly. One is a policy that the Clinton administration put into place in 1996, in which the then INS adopted a policy of non-interference in labor disputes, recognizing that if the agency should not get involved when employers either call immigration on themselves, or that there would be some negative impact on labor standards if the agency were to be involved during a labor dispute. That's was known then as Operating Instruction 287.3a. And it really, if we had applied 287.3a in every processors and a litany of other instances of immigration enforcement during labor disputes, the outcome would have been actually very different. The other administrative fix or administrative approach that we're suggesting is that the agency really think about what the balance, the enforcement value of some of its practices versus the negative effect on workers' rights. And the Social Security No Match Program is a good example of that. The Social Security No Match Program is a program that was started in 1994 by the SSA, never meant to be an immigration enforcement program, just simply a program that SSA sent letters out to employers asking them to verify that their names and numbers of their workers matched. And that was done for purposes of actually keeping the SSA database clean and making sure that workers were credited the earnings that they were supposed to be credited. This program gradually has become an immigration enforcement tool. And 2 years ago, the Bush administration actually made very clear that they were going to use the program as an immigration enforcement tool, requiring that employers take certain steps upon receipt of an immigration of a no-match letter. If you look at this program, the enforcement value of this program is very small. Why? Because DHS doesn't know what employers get no-match letters. They can't share that information. So unless DHS is clairvoyant, it can't go after the employers that are getting these no-match letters. The impact of these letters on workers' rights is huge, and we've documented that in a lawsuit that the AFL-CIO, the ACLU, and the National Immigration Law Center and others brought against the Bush administration. Now, I don't want to go into too much detail, but the point is that there are many, many instances, or there are many ways that the agency can really rethink its administrative policies to make sure that the impact that it has, that, in other words, that this balance isn't affecting workers' rights, because in the long run, that's really not advancing the agency's own mission. Thank you.
Great, Anna. Thank you. And I want to come back to some of those labor enforcement questions as well. But just to finish the framing, Stuart, can you talk a little bit? You were in the middle of the Bush administration's effort at comprehensive immigration reform the last time around. Give us the insider's view, and what does it portend for the future?
Conflict and failure. But let me see if I can tease that out a little. A couple of thoughts about immigration policy. It is a remarkably difficult field, and it exposes the hypocrisy in virtually all of us when we think about immigration. We almost all want two very different things from the immigration policy process. When people describe the immigration system as broken, it's almost a guaranteed bet that they helped break it, and that they like it broken. They hope that if it stays broken long enough, they'll get what they want out of the system. I've been struck by that. The reason that we have that problem and some of the hypocrisy that it's at the bottom of the system is that for both the Democratic and Republican parties, a major element of the winning coalition that the party brought the party to power is going to be a lot of people who do not want to see the immigration laws enforced. On the Republican side, business, by and large, doesn't want to see the immigration laws enforced particularly aggressively. My introduction to immigration policy was sitting down with a bunch of agricultural interests and lobbyists, and practically the first words out of their mouth when they were introducing me to their immigration policies was to say, I'm from this particular farm organization, and we hire illegal workers legally. And I said, what? You know, can you imagine somebody saying, yeah, I'm from a particular industry, and we dump pollutants into lakes legally. It's a bizarre notion, but it was quite common in the immigration context. At the same, and of course on the left, there are interest groups identity politics groups and the like who are determined to avoid enforcement of the immigration laws to the extent possible. That set the stage for immigration reform, and here what I thought I would do is use two quotations that I think describe the immigration reform efforts that we made in 2006 and maybe again in 2007. And the two quotations I'd like to offer are first from Talleyrand and then from Bowling for Soup. Talleyrand said about the returning aristocracy after the French Revolution ended, he said that these people have forgotten nothing and learned nothing. They want to go back to exactly the world that they had before the revolution. And, of course, Bowling for Soup famously said about Debbie, her two kids in high school think that she's uncool because she's preoccupied with 1985. In both of those cases, what we're seeing is that the people who came back for the immigration reform debate in 2006 and 2007 had learned nothing and had forgotten nothing and were preoccupied with 1986. They wanted to have what they had the last time. They wanted to sell the same car to the American people. And the effort to persuade people to accept what amounted to a Xeroxed version of 1986 liberalization or legalization plus an enforcement improvement, that effort is what failed in 2006. I described it at one time as track changes immigration reform. You get out the 1986 bill. You look at the new bill, you say every change, you mark every change, you give it a plus or a minus, you say, okay, that's good for me, bad for me, good for me, bad for me, and it's got to come out better for me this time than it did in 1986. Well, when every interest group is done applying the track changes analysis to the bill, you end up with a bill that looks exactly like 1986, and you can't sell that to the American public this time around because they don't believe, unlike a lot of the immigration groups that follow this closely, most Americans don't think that 1986 was a success. They think it was a failure, that they got the legalization and they didn't get the enforcement that they were told they were going to get, and they're back with a problem that is 4 times as large as it was in the past. So we encountered that. That's what I think failed in 2006. Our strategy in 2007 was to do something that I think the Obama administration is going to have to do. We basically squeezed our natural constituency in business. We said we're going to make life harder. We're going to make a bill that is harder on the people who think that we're on their side and that they're on our side, because only by demonstrating an enthusiasm for enforcement can we actually demonstrate to the American people that this is not going to be a complete repeat of 1986, that we're going to actually get enforcement and we aren't going to be coming back next time with 40 million illegal workers who want to be brought into the system. And that's why we came up with a number of provisions relating to E-Verify and to identity theft that were designed to show that really immigration enforcement is possible and to show through our actions and enforcement actions that enforcement was going to continue to occur and that it could actually succeed. And we actually brought down the number of illegal immigrants entering the United States quite substantially. My guess about what's going to have to happen for immigration reform to be successful politically, with the 60% roughly of the American public that believes in enforcement and is skeptical about the 1986 reforms, is the Obama administration is probably going to have to find some symbolic issues or some practical issues in which it says we're going to turn to the right, we're going to actually make unhappy some significant part of our governing coalition and pick a fight with the identity groups or the labor unions or somebody over enforcement. And there are any number of possibilities. I think that actually David's suggestion that the immigration reform will include substantial amounts of use of E-Verify and anti-identity theft is probably a step forward, because that really does open up the prospect that there could be substantial enforcement of the immigration laws without the usual raids and separation of families and the like. Other possible ideas for picking fights that I think are symbolic but likely to persuade Americans that this time the administration, that the government actually intends to enforce immigration law. An end to this pink sheet confidentiality provision. The notion, in 1986, the notion was, well, we can't possibly expect anybody to come out of the shadows and register for legalization unless we offer them a guarantee that they will never have the information they supplied used against them in any immigration or other legal process. That turned out to be a significant problem for, among other things, terrorism investigations. Some of the first World Trade Center bombers benefited from taking action benefited from the confidentiality provisions. We were not allowed to look below the little pink sheets in their immigration files to see what addresses they had given and the like. And we've had long history now, since 1986, of people coming forward out of the shadows to register for programs without guarantees of confidentiality. It's a remarkable shibboleth for the left that we have to guarantee confidentiality. It's something that if as part of legalization, we could get rid of the confidentiality assurance so that we could use the information for anti-terrorism and criminal investigations. That'll be a real step forward. The last idea, the labor unions will not like this, is a temporary farm worker program. It is as close to a certainty as possible that the day that legalization occurs for people who are working in the fields, those people will stop working in the fields and go to work in construction because they're legal. And if you're legal, you can get a much better job. You don't have to work in the fields. So the day after legalization takes effect, farmers will not have any labor. And they are not prepared to simply give up their farm because the immigration law has changed. And the result of that is that illegal workers will have to be hired 3 weeks after legalization takes effect. And farmers will do that, and we will be starting again the whole process of building a class of illegal workers that got us into the fix that we've been in twice before. I don't see a solution other than a temporary worker program for agriculture, but whatever the solution is, we have to recognize that we are in the process of creating a new class of illegal workers if we simply legalize without having some solution for the farmers who need workers the day after legalization. Thanks.
Okay, thanks, Stuart. And I know that there are a number of empirical assumptions or statements embedded in what you just said that many would dispute, but we'll have a chance to come back.
No doubt.
To come back to those. Let me turn back first to the detention issue that David raised with regard to appearance rates. And I think, David, critics of detention would say that some of those failures to appear were during a period of time when there was no real effort by DHS to ensure appearances, that notices were sent to old addresses, that there was no method in place to monitor the location of individuals who had been released, and so on. And then I think Judge Katzmann referred to some practices of DHS that exacerbate the difficulty of having fair hearings both at the administrative level and judicial level, including in particular transfer and prolonged detention. So the question, I guess, would be, in terms of the detention policies, one would be making individualized decisions by immigration judges of who should be detained and who should be released, rather than having a detention system which sweeps very broadly without that kind of individualized process, and not transferring people to remote locations, but rather allowing them to stay in places where they do have counsel so that they could pursue their claims. Is DHS considering, or would it consider, a kind of a pilot program of real closely monitored and effective release from detention based on individualized determinations to see how and whether that would work? And then I'd like to ask Judge Katzmann to comment on policies or programs that DHS could adopt to facilitate the appointment of counsel in immigration proceedings and before the federal court, so that we could have a system where the percentages are not as low as you indicated. But David, could you talk about a program of really seeing whether release could work in a real way rather than the kind of artificial practices that have happened in the past?
Let me address a couple of parts of that. Each of these elements that you talk about is part of what's being looked at in this overall comprehensive review of our detention practices. As I mentioned earlier, there is certainly one of the factors that Dr. Shuro is looking at is ways to make sure that our detention practices minimize any interference with the counsel, obtaining counsel or sustaining a counsel relationship that has already been established. People are moved to remote locations. There are big logistical problems in resolving that. There is certainly an interest in getting beyond that, but at least until the recent recession, communities often were not clamoring for new detention facilities, and particularly not in the areas that were close to large immigrant populations. I think there are ways that we can deal with that. It's being looked at, but there is a real challenge, just given the array of detention facilities that we have available right now. On release programs, there were, I think many people in this room know that there have been studies in the past, there have been pilot projects. The Vera Institute ran a project in the mid-1990s for INS called the Appearance Assistance Program, or sometimes called the Supervised Release Program, that I think showed a lot of promise for a more intensively supervised program to help assure that people would show up at all the critical stages of the process, including they gave a lot of attention to making sure that people would show up, or maximizing the chances that people would show up also at the end if they didn't win their case, show up actually for removal. There's more that we can do along those lines, and that also is being looked at. There's some elements of that are being done now in a variety of other ways, and some efforts to try to use other alternatives to detention, which includes certain forms of electronic monitoring that are being looked at. But I can say that all these are being given close attention, and I think it's significant that there is one person with full-time responsibility to organize that kind of study and pull together some suggestions and recommendations along those lines. You mentioned about immigration court review of release decisions. I'm not sure that's. I think the real focus has to be at an earlier stage, at the initial decisions about release and the structures and mechanisms that are available there through the DHS process. Certainly with some review by IJs, that's a part of our system for everybody but arriving aliens right now. But there's a really interesting study from, I guess, the 1980s, and I don't think the underlying dynamics have changed. The American Bar Foundation did it, that showed a value dissensus among those who set the initial terms for release and then immigration judges when they would review them and usually reduce the bond amounts. And it documented a really interesting split in focus. The initial decision makers at what was then INS would focus on, are we really going to be able to see this person all the way through to the end of the process for removal? Immigration judges tended to be focused much more on, well, are they likely to show up for the hearings? And if so, reduce the bond. But I really think the system, all of us who are looking at reforms, And I really emphasize that people who want to see comprehensive reform, who want to have more humane detention programs, need to help us solve this problem and think about it all the way through. It's not good enough to satisfy the general public and a lot of members of Congress who are looking at this, to have people show up for hearings. There needs to be a capacity to find people at the end of the process if they don't succeed in their defenses.
Judge Katzmann, you want to talk about what DHS could do to help with counsel?
First, I would like to say that Dr. Schriero has really reached out to the various communities, and I've met with her, and she's meeting with the task forces that I created in the Second Circuit on Monday. So we're hopeful. I think that what needs to happen under the current framework is a public-private partnership that is aimed towards facilitating counseled representation in cases. At present, only $4 million is spent by the federal government in a legal orientation program through EOIR, the Executive Office. It's an excellent program which seeks to facilitate counseled representation in group settings, individual settings. But with only a $4 million budget, the reach of the program is extremely limited. For example, there is no such program in New York. We hope that there will be, and I'm confident that there will be based on discussions that I've had. And if you had a program in which you had adequate screening of cases by groups such as the Legal Aid Society, Human Rights First, and if you could ramp up significantly the role of lawyers in practice to work on these kinds of cases. That's one of the objectives of our task force in New York. You could begin to make a difference. And certainly, if you could have a change in policy administratively, which limited transfer except in those cases where it's absolutely necessary, so that lawyers who are representing those in these detained facilities can stick with the detainees. I think that would be an important step forward. And I think that my sense is that there is an effort within DHS to explore these opportunities, and within the EOIR in the Department of Justice, I think that there is also interest in expanding the legal orientation program. What we hope to do in New York is to make New York a pilot project for these kinds of efforts. Let's see what would happen if we had enough resources in a public-private kind of way, drawing upon the full range of groups that we have working with us, see what would happen. There had been a proposal actually made in 1999 by Senator Moynihan for paid governmental representation in 3 districts. It never went anywhere. And in the current environment, that may not work. But at the very least, with respect to pro bono representation efforts, government can do a lot to facilitate those kinds of efforts with very modest expenditures.
So, David, just to put you on the spot a little bit, would DHS commit in a place like the Second Circuit to not transfer individuals who are able to get counsel through a pro bono program like the one that Judge Katzmann is outlining, so that the effect of that could be studied and tested in a way that then allows us to measure what the benefits or the costs and feasibility would be of providing counsel in every case?
I get the feeling you're going to slide me a prepared document for me to sign here.
Just sign on the dotted line and we'll give it a try.
What we can commit to is exactly what's going on already. Dr. Shuro is going to be meeting with the people there to look at that. This is really a part of the agenda, but again, it's a complicated set of circumstances. We've got to figure out about exactly what we have available, what's the likely impact on numbers, what sorts of facilities are available in the system, because there still will be some people who will be detained. So I can say we're very sensitive to this issue. We've got mechanisms underway to try to address it, cooperating with a variety of players, public and private, and we will proceed with that. I should say one other thing. I have a feeling maybe we've inflated the expectations for Dr. Shiro a little bit too high. I don't think she can solve all the problems in the system right away with her first report when it comes out in a few months. But I do think we can make a lot of headway on a number of these issues. And again, as I said earlier, we've got to stay in this for the long haul. It's going to be a set of incremental steps. I think we can make some real progress on this, and let's stay with it and work together on that.
There's an old saying that judicial reform is not for the short-winded, and this is an area where I think we have to be patient, but at the same time we have to have kinds of signals that indicate that we will be moving forward.
Let's turn back to the labor question just for a moment. And Anna, you laid out some of the areas in which labor enforcement could enhance immigration enforcement by actually enforcing the labor laws first, rather than the immigration laws as the priority, and an apparent lack of focus by DHS on encouraging the labor law enforcement. Could you elaborate on that just very briefly, and then David, I would ask you to respond, and then Stuart, I want to come back to you on some questions.
Sure. So just focusing on the issue of raids. DHS, I mean, it is no secret where the current undocumented population is concentrated. It's in industries, in meatpacking and poultry, services industry, and agriculture and construction. In the raids that are happening in these particular industries across the country, there is, like I said earlier, no focus on enforcement of labor laws. And meatpacking and poultry is a good example. There was the last compliance study that was done of the industry as a whole by the Department of Labor in the year 2000 found that the industry as a whole, the poultry industry as a whole in the United States, was 100% out of compliance with wage and hour laws, 100%. Now, these are not mere paperwork violations. The largest percentage of those violations were actually overtime violations and minimum wage violations. So it seems just logical to us that when there's an enforcement action in any of these industries, that it's really the economic incentive that's driving the hiring and the economic exploitation of undocumented workers. That should be front and foremost in these industries, particularly when there's some sort of worker organizing, whether it's a labor union organizing, whether workers have filed wage and hour lawsuits, that sort of thing, that addressing the economic incentives should come first, or at least go hand in hand with enforcement of the immigration laws. That's not happening, and that could easily be addressed through simple administrative rules like the INS operating instruction.
So are there new efforts underway to coordinate the work of DOL and DHS more? Can we foresee the kind of enforcement that Anna's outlining and the kind of agreements about not doing enforcement during labor disputes, or more broadly enforcing the workplace laws first?
Yes, there's definitely work underway to try to do much better coordination with the Department of Labor on these efforts. Part of our overall effort, we've already announced some of the early stages about a change in the focus, as I mentioned earlier, about our worksite enforcement efforts to concentrate on developing cases against egregious employers. As part of that, clearly, we want to pay attention to the labor law violations that are there. It's a long-term effort to work out those protocols. Again, for every department, there are a variety of priorities that they need to deal with first. It's only been 5 months into the administration, but we're definitely working on that, and we're very much aware of the way in which violations of immigration laws often go along with labor law violations.
Can I slide you a document?
So, Stuart, you raised a lot of kind of provocative points about comprehensive reform and the way in which it ought to be considered or implemented. The Bush administration supported comprehensive immigration reform that would include a path to legalization. There may be a lot of differences about what exactly that should be. The question I'd like to ask you first is, in your experience, the agency ready for a legalization program? What's necessary to get it ready, and what would it actually mean? And then, David, I'd like you to respond to that as well. And then the follow-up question for Judge Katzmann would be, what's the role of the courts in overseeing an implementation program, given the experience from 1986, where the courts were critical in enforcing the parameters of that program to ensure that it was faithfully implemented? And I'll elaborate on that just a bit.
Okay, let me just take two. Of course it's not ready. It couldn't possibly be ready. This is a staggering administrative burden. We began planning, and I know that the administration has continued the planning for that, but let me just give you two examples of changes that would be necessary. The assumption of immigration reform is if we legalize the people who are here illegally, that should make life easier for the enforcement guys because they won't have as much to do. They'll be like the Maytag repairman, sit around, drink coffee, and wait for somebody to try to come across the border. That is not at all what is going to happen. You are not likely to be eligible for legalization if you've committed crimes. It's sort of hard to imagine a legalization program that would allow felons in particular to become citizens of the United States under the program. We did an estimate of how many people were likely to be caught up by the various exclusions that were in effect in the last set of immigration reform proposals, and it was about 1 million or 1.2 million people who are here illegally who either weren't here long enough or had committed a crime of some sort and therefore weren't going to be eligible for legalization. If you want to be credible about how this is going to really solve the problem in a way that won't bring another set of illegal populations in another 20 years, you have to say, how are we going to find those folks, that 1 million people, and make sure that they are deported or go home voluntarily? That is a massive job. ICE has never found 1 million people in a year, and I think they might have found 300,000 or 400,000 in a year, but they found them mostly in prison, which is kind of like shooting fish in a barrel. So you're going to have to ramp up remarkably the amount of enforcement that ICE does, and they're going to need more resources to enforce the law. That's one unexpected consequence of immigration reform. The other is that you're going to have 12 million cases to adjudicate in which people have every incentive, if they aren't here legally, to make up documents that are designed to prove that they qualify for the legalization anyway. The fraud problem is astonishing and almost intractable because anything you do to accommodate legitimate applicants who aren't well organized and haven't saved their documents is going to make fraud much easier. All of those documents and all of those stories are going to have to be examined individually under most of the proposals for immigration reform that I've seen. 12 million cases is 3, 4, 5 times the ordinary caseload of USCIS. So they're going to have to hire 4 times as many people as they have working there now to run these things through. And then they will, like the pig and the python, they will move on and eventually they'll end up in the Second Circuit. This will, I think we probably are close to the point where you cannot possibly adjudicate the number of people who will apply for legal status. It will discredit the entire litigation system to the extent that it isn't already discredited. It will discredit the idea of individualized justice for every applicant. We are still litigating, believe it or not, the 1986 immigration reform. There are still people making claims and obtaining legalization through litigation. That's part of the broken system we have. We're going to have to find a way to minimize the amount of litigation, control the litigation that comes out of this. I say that because I've described in other circumstances immigration reform for DHS is like a box full of bonbons. It's an instant on the lips and a lifetime on the hips. After immigration reform, if it happens, there'll be an enormous self-congratulatory conference where handshakes all around, ceremonial signings. Everybody will say, "That was great. We're done with that." And DHS will be left to pick up the mess afterwards, and it faces 20 years of failures, scandals, frauds, judicial reversals, which in the end are going to discredit whichever administration is in authority to try to implement that, which I'm guessing is going to be this administration. This is not a good outcome for the administration in the long run, and so planning for this is going to have to be a very high priority for the administration and particularly for DHS.
Hearing you speak gives me some insight into why the Bush administration might have had difficulty selling this to Congress. So, David, how does the agency get ready?
Well, let me just say, I hear what you're saying about selling it, but we do have to be very realistic about the practical questions that arise in trying to implement this and to plan and prepare for that. The level of adjudications, the issues about judicial review, and I certainly agree with Stuart. There has been a lot of very casual statements, and some not so casual, done by scholars about how, legalization will greatly reduce the enforcement burden, and maybe we can shift a lot of resources from enforcement to other sorts of things. I wrote an article a couple of years ago, well before I ever thought I would be blessed or saddled with the responsibility for trying to work on some of these issues, just trying to emphasize that. It was called 8 Myths About Immigration Enforcement, and it really, I think we have to be very serious. Enforcement has got to be a serious, sustained part of the long-term picture for immigration reform, and there will be some parts that will be complicated depending on some decisions about the exact shape of immigration reform. Judicial review is also a really challenging question. The courts have been quite concerned about the level of the huge chunk of their caseload that's now made up of immigration cases. Some of that was certainly foreseeable when Congress and the executive branch decided in the mid-1990s to greatly ramp up enforcement resources. The courts were cushioned from that impact for several years because of the problems at the BIA and the backlogs that developed there. Once they cleared the backlogs, there was going to be a big lump that was going to reach the courts. The methods that were used, as Judge Kessman referred to in 2002, to clear the backlogs really quickly wound up not only sending the normal percentage of cases onto the courts, but also increasing, at least contributing to some increase in the appeal rates. We need to think really hard about what that's going to mean if we have for an adjudication system here. Congress tried to deal with that to some extent, really minimized judicial review back in the 1986 system, but from some decisions that allowed class actions and some decisions on remedies and keeping open the application period for a long period of time, I think it really exacerbated some of those difficulties. There needs to be some very careful thought about how can we do this. And one can raise question. I know people think about judicial review as the ultimate guarantor of fairness and all that, but if we're too demanding on that, I think it's going to make the system very difficult to work. We need some guarantees of fairness, but I think we have to concentrate on applying resources to the administrative system and having fairness there. This is, after all, it's hard to make a case that legalization would be something that would be a life, liberty, or property claim. It's up to Congress to decide whether or not to bestow it. And, I don't know whether we can get there, but some ways to try to minimize and streamline judicial review so that it's a manageable system and doesn't impose another huge load on the court systems that are just now beginning to adapt to the large load that came out of the enforcement changes in the 1990s. That's really essential. Those are all really difficult and challenging problems.
I mean, just a footnote on the 1986 issues that Stuart mentioned. The cases that are still pending in the courts from the 1986 legalization are all about the court's jurisdiction to provide a remedy for the violations that the courts found with regard to the implementation of the 1986 legalization system. The challenges were to the rules, the regulations, and the practices. They were uniformly rejected by the courts the way the agency was implementing the program. But then there has been protracted litigation over what kind of a remedy the courts can afford. And part of that was driven by the time limit on the legalization application process, that in 1986, every applicant had to submit their application within 1 year or be barred forever from applying. And in terms of the implementation issues that have arisen, in terms of the implementation problems that have been identified, one question that comes to mind is, does it make sense to have that kind of a deadline? I think we can all understand the reasons why a deadline was imposed in 1986, but does it really make sense? And if you're expecting an applicant pool of 12 million people or somewhere in that neighborhood, is it even realistic to have an application deadline, and certainly one like the 1 year one from 1986? And if not, how does the system work? And wouldn't the agency be better off not urging, seeking, or supporting a short application deadline of that kind?
Lucas, all of this is driven by the fraud problem. The highest level of illegal immigration we've ever had is not when the boom years of the 90s or after 2000, but in 1986, which almost certainly people coming over who said, if I'm there, I can pick up some documents and file to get legalized. If you can find a way to address the fraud problem, you don't need the 1 year deadline. But if you have no deadline, or effectively, then people will be coming for years to engage in fraud. One of the interesting ideas that I think is worth exploring is, could you completely break the model and say, if you want to be legalized ever, then you need to register that you're here. No promises. You just need to tell us you're here, and you're not going to be our priority, but we're not promising you legalization, but we are promising you that we will treat you as having been here for a couple of years when the time comes.
I just want to just comment on the whole approach that we've been hearing about to legalization, which is really an approach based on exclusion, sort of finding out who shouldn't be here, who's committed felonies. And our approach is actually the complete opposite, because what we see from workers' standpoint is that we have right now two classes of workers, 12 million or 8 million working people. Of the 12 million, 8 million are economically active, who have no rights, essentially, or can't exercise their rights. So from the standpoint of workers, not just undocumented workers, but workers across the United States, what makes sense is to have an inclusive, swift, and practical legalization program. And that means, in the practical legalization piece, it means looking at the kinds of exclusions that we've been talking about. Excluding felons. I mean, that's a value-laden exclusion. Of course, we don't want felons in our midst. But who are felons right now? In some states in the South, felons are people who are working because the state has decided to criminalize work. Felons are people who are driving without a license because the state has decided to criminalize that sort of thing. So just having a blanket exclusion based on some anti-immigrant policy that a state decided to implement is really not good enough. So in our view, we really have to look at, how do we get this done? How do we do away with the two-tiered system that we have right now? And that's going to require really new thinking. It's going to require partnerships, public-private partnerships, the kind that we're talking about here, but in a new mechanism for those partnerships, partnership with churches, with community-based organizations, with labor unions who can actually implement this kind of a program. And also, I mean, let's not forget, the United States admits 30 million foreign visitors into the United States every year. We screen those folks, and we screen them in a way that we're comfortable that we're not letting in 30 million terrorists in the United States. So let's take lessons from how we do that and apply them to a legalization program, because it is absolutely in the national interest right now, if we could do this tomorrow, we should, to legalize as many of the undocumented population as we possibly can.
Judge Katzmann, do you want to talk about the role of the courts again?
I would simply say that, of course, that the courts leave to the political branches the legislative reforms or administrative reforms. But whatever reforms are enacted or changes that are enacted, I think it's very important to keep in mind systemic consequences to the institutions that are charged with enforcement and adjudication. And when legislation is typically drafted in almost any area, there is not much attention given to judicial impact or administrative impact and what it costs. And that always has adverse consequences down the line, because it diminishes the capacity of the institutions to implement the changes that are made. So whatever changes are made, I think it's very important to think about what is the impact in terms of the functioning of the institutions, the resources needed by those institutions. Those who say, and I wholly agree with what Stuart and David were saying, that those who think that the problems will be eliminated after legislative change are, I think, not looking at the reality of the situation. So for those people who find themselves in a different position after legislative change, they're going to need effective legal counseling, and that's going to be very, very important. They are going to need the kinds of guidance and resources necessary to comply with the laws as changed, and that's not cheap. It costs money. So I think that we should keep that in mind and have no illusions about the difficulties. I think it was in '86, there were some programs that were in place to provide some support, but wasn't enough. And one of the reasons why we still see some of these cases coming down is that because of the absence of adequate counseling, and if there had been adequate counseling, we wouldn't be seeing these cases.
In just a few minutes, I'm going to welcome questions from all of you. So get ready and whatever you want to ask. I want to just turn to one other aspect of the caseload, and that is the very front end of the process, and that is who ICE pursues, and in particular the exercise of prosecutorial discretion at the front end before the immigration judge. And this is something I think that lawyers representing individuals in proceedings and advocates, and I know, David, you've thought about this. This has been an issue for a long time. To what extent is there careful exercise of prosecutorial discretion at the front end in terms of who gets put into the process? And then, Judge Katzmann, from your perspective, when the cases reach the Court of Appeals, to what extent has there been careful scrutiny by the agency of which cases to aggressively pursue in the courts? To what extent has mediation proved fruitful? And I know I've heard asked who exactly is the client for the government who's in a position to decide how a case should be resolved if the court feels that mediation is appropriate. So, David, could you talk a little bit about prosecutorial discretion, then maybe Judge Katzmann, your experience with that?
Yeah, institutionally, I do think we could do a better job of deciding carefully about which cases we're going to actually put into the removal proceedings. It's partly a matter of drafting guidance, but it's partly a matter of some essentially institutional cultural changes. There are a number of processes now where somebody maybe receives an application from someone. The application is not they decide that it's not valid. There are circumstances in which they're then immediately put into removal proceedings. And if you took a step back and decided, well, where should we really apply our removal resources, maybe it doesn't make so much sense to do that. We should be prioritizing other cases in other settings. So that's important, and that we need to do more on that. There are possibilities now under some guidance that was put out by the Legal Counsel's Office in ICE several years ago for the lawyers to take a somewhat greater role in exercising prosecutorial discretion at the time when it reaches the immigration court setting. But that's a difficult stage at which to do it and to essentially throw out the work that has been done before. It'd be much better if we can get a handle on that at the beginning stages. But let me just also again say there's some reasons why we shouldn't expect that that's going to take all of the cases out of the system that others might regard as, well, why are you going after that grandmother? Two particular settings. If somebody's applying for admission to the country, they're at the border coming in, you can't just sort of say, oh, well, we're going to ignore it and just walk in. You have to make a deliberate decision about that, and there is some authority to parole there, but it's a different setting from just a circumstance where you decide, well, where are we going to go apply our enforcement resources and begin to charge people. Second one is in asylum. And we made some very important asylum reforms in the mid-1990s. One key part of that, though, was to say that if somebody comes in and applies affirmatively, we grant a lot in the affirmative asylum process, but if they don't qualify and they're otherwise out of status, they're going to be put into removal proceedings right away. Partly that's so that they will have a full opportunity in that adversarial setting to pursue their asylum claims, and many people are successful at that stage who were not successful in the affirmative asylum process applying to USCIS, but also to indicate that there are some consequences, something that wasn't so evident in the early 1990s. If people file a really ill-founded asylum claim, it's not as though they're going to get some kind of documentation and be in the system. That's worked pretty well to keep the asylum system in reasonable balance over recent years. So I don't know that we're going to be able to move away from that kind of charging in that setting.
I think that from my vantage point, at times I wonder if there might be a more holistic approach where DHS and DOJ are in greater coordination. For example, we often will see cases where someone is being essentially subject of proceedings where it turns out that he or she is married to somebody who is legal, and through other processes, that person who is being pursued by the government would at the end of the day be able to remain in this country. And we see enough of those cases, I think, that a lot of us wonder whether this is something administratively the government might look into. There have also been a number of occasions where in arguments we will encourage the government's lawyer to go back and look at the case and work with DHS to see if there might be some sort of resolution of the case. And that works from time to time. But I think that the kinds of things that David is talking about in terms of rethinking some of this would be helpful.
And David, if I could just follow up with that, when the case is in the Court of Appeals, the case was initiated by ICE, prosecuted before the immigration system by the ICE trial attorneys or by the trial attorneys, and then ultimately within the Department of Homeland Security, and then ultimately reviewed by the Board of Immigration Appeals, which is in the Department of Justice, and then the government is represented by the Department of Justice Civil Division typically. Who makes the decisions on resolving and mediating that case? Is it the Justice Department, the lawyers, the EOIR there? Is it DHS that brought the case initially? How does that work within the interagency process at the government?
It depends on the stage where it is. There's under some changes that Attorney General Gonzalez announced, there are oil is given a role that's part of the Civil Division, Office of Immigration Litigation, to look at cases and maybe suggest that some of them should be given another look based on how it seems to be shaping up in the Court of Appeals. So if that happens, there's consultation among the agencies. If it's at the BIA stage, I mean, there are instructions to be alert to situations where some sort of discretion like that may be used. And if it's at the BIA stage, it tends, and it's just for the lawyers, for the attorneys for the government bringing it, then that's, of course, just a DHS ICE issue.
But once it's in the Court of Appeals, it's who has the ultimate, makes the ultimate decision. Which part of the government, not which person, but which part of the government makes the ultimate decision on whether.
Well, I mean, oil attorneys are handling it at that point, but if it seems to present a situation where this should at least be considered, then there would be consultation.
There's microphones, I think, for those of you. Please raise your hands and the microphones will be passed around. Thank you. Yeah, go ahead, please. And then
All right. I had a question about medical care for detainees. Under the Bush administration, there were problems both with bad contractors giving substandard medical care and also a very low standard of care that they were being held to. And so for David Martin, I wanted to know on both of those fronts, to what extent is the administration planning to address those problems?
Extensively. I mean, to the extent maybe I should give it to Stuart on the situation in the past, but there have been there have been some changes along the way. It hasn't been a static situation. There have been changes in the institutional structure to try to improve the performance, to have a number of monitoring mechanisms that look at that, among other things that they deal with in monitoring and reviewing the compliance of the facility, the detention facility, with the standards that are set. There were also changes that were made to have more performance-based standards for the detention facilities. And again, very specifically, one of the mandates that the Secretary gave to Dr. Schreiro was to look at the medical care situation there. So, I mean, I think there has been progress that's been made in that. It's a difficult overall set of issues, but there's been some progress that was made before we got there. There's attention to that as well now.
Yeah, I think David's right. It's important to know that DHS didn't initially assume responsibility for the medical care of detainees, and that was something that was transferred, I think, from HHS to ICE fairly late in the process. ICE began to make changes. Then there was a lot of publicity about several old stories. But there is a fairly consistent effort to improve the medical care of detainees that began 2007 or so with DHS and has continued through into the next administration.
So, question in the back here, and then Yep.
I have a question concerning primarily minors being deported and detained and deported without, to my knowledge, any hearings. In San Diego, they segregate pregnant young women who either are pregnant or have children. And a very close friend of mine is a teacher that teaches these young women. And they've been doing trolley raids where they've been detaining them and then dropping them off in the middle of Tijuana without any hearings a few days later before they're able to do anything about it. And the young women don't know anybody. Tijuana is fairly dangerous right now. And have no family there. So are there any legal remedies because they're minors that would be available to them in these situations?
Well, I mean, there has been, I'm not aware of that particular situation, but there have been a number of steps that have been taken legislatively and administratively over the last few years to change that. The arrangements for custody and overall arrangements for minors was transferred to the Office of Refugee Resettlement in HHS. There have been some difficulties in working out a cooperative, a smooth set of interrelationships with DHS on doing that, and they've made arrangements for what Congress intended to be better care, better provision for unaccompanied minors in that kind of a setting. So I mean, there are efforts there. There's still implementation bumps in the road that need to be worked out. And if you have a specific example like that, I mean, I think it should be brought to the attention of those at HHS or the local ICE office.
Yeah, here.
And then right in the back.
At the end of, towards the end of the Bush administration, ICE started using more aggressive enforcement tactics, like the criminal prosecutions and what Anna was talking about in Postville. And I was wondering what enforcement under the Obama administration is going to be looking like, especially with all this political pressure to ramp up enforcement in order to have a real conversation about immigration reform.
I guess that's for me too.
You're a popular guy, Dave.
You want me to answer?
Well, you can defend. You can talk about Postville maybe, but one of the kinds of charges that was made in Postville, criminal charges. Of course, the issue went to the Supreme Court. The Supreme Court said you couldn't do it just on the mere fact. You couldn't charge identity theft just on the mere fact that you were using the actual identity papers of another person. There had to be showing of a mental element. Now, you know, there may be circumstances where we will do that and proceed with the additional approach. We're committed to enforcement, to serious enforcement. We're going to go ahead, but as I said earlier, we're trying to think about it in more systematic ways with the focus to be on the unscrupulous employers, and I don't think I mentioned this earlier, but also on critical infrastructure sites or security-sensitive sites and the workers there. So, you know, there's an array of enforcement initiatives. We're committed to doing that. We're going to see that through, in addition to really beefing up the capacity and the accuracy of E-Verify. So on many different fronts we're doing that. And there are other efforts too where we're trying to focus in a more careful way, but a very serious way on aliens who are undocumented aliens or aliens who are out of status who are involved in the criminal justice system. And there are a number of promising developments for making that kind of cooperation work better with state and local law enforcement, but in ways that minimize the chances that there'll be some misunderstanding and there'll be a misuse of local law enforcement authorities in light of that.
ICE did make a switch to focusing on criminal investigations of employers as well as employees where there was evidence of a criminal action, rather than just checking records to see whether people had kept good records of their of what ID was presented to them. There is an inclination, and I think again this is the 1985 hangover, to say, well, really, illegal immigration is kind of a victimless crime. These are folks who are just trying to make a living. Why are we treating them criminally? But the fact is, increasingly, getting illegal work in the United States requires that you steal an identity from an American. If people are checking Social Security numbers, as probably 1 hire in 4 is now subjected to a check to make sure the Social Security number and the name match, there's a premium on getting a real American's ID and using that to get a job. And in fact, it's my understanding that people who are looking for IDs will pay a premium for precisely that this is an actual name and an actual ID, which does kind of raise questions about whether the people who were charged with aggravated ID theft could have been demonstrated to have known precisely that they were using a real person's ID. That is not a victimless crime. It will screw up people's tax records. It will screw up their Social Security records. It often screws up their credit records. And most remarkably, as we move toward creating electronic medical records, once you've got a fake identity for an American, the temptation to use it to get medical care is very strong. And that means that there's going to be a record for the American whose ID is stolen that says his blood type is something other than his blood type actually is. So that there are very serious consequences for the identity theft that often now is part of getting illegal jobs.
Okay, I'm sorry, but we are short on time. I can take one more quick question, and then we're going to have to wrap up. Yeah, I see an animated hand there, and then I'm going to ask you, but please, very briefly.
Sure. This is a question for Mr. Martin. There are now over 60,000 non-citizens in federal prison. This is pretty costly. There is authority that was enacted in 1996 that allows the Attorney General to send non-citizens who have not finished their prison term home. The states are using this. The federal government has never used it. I'm wondering if there are any plans afoot to activate that statute, 8 U.S.C. 1231 A4B, I think, to be precise, for federal prisoners.
Yeah, we affectionately know it as INA, Section 241 A4B. But just that's the old dispute between the immigration lawyers who focus on the INA numbers and others who focus on 8 U.S.C. But I'm being frivolous on that. But I mean, it's a serious kind of issue. I don't know quite where that is. I know there have been efforts to look at that. It's available. This is the provision. It's available for nonviolent offenders. Is that right? Yeah. And for earlier release if the appropriate official decides, and then for tied in immediately to removal to their home country. It seems there are advantages certainly to making wider use of that, and there are conversations. I don't know quite where those are now. The Justice Department is really the forum for thinking about that centrally right now.
Thank you all very much, and please join me in thanking our panel. I have been asked to announce that there's a luncheon now coming up, as you know, with Elizabeth Warren, which is in the Grand Ballroom, and at 4:45 there's a moot court in the Colonial Room, followed by the banquet. Thank you all very much.